Okay, great. Well, I'm going to kind of go through this quickly because I know I want to make sure we're respectful of time and maybe hopefully have a little bit of time at the end for some discussion, because this topic usually does bring up some discussion. But for those of you who don't know me, my name is Ralph Flick. I've been a member of this club now. It's amazing. I was thinking about it. I joined the club back when I first moved to Washington back in 2008. So it's been a while now. I still feel like the new kid on the block, but it's been a while. But I'm a lawyer by training, and in the last 2016, I joined the faculty at PLU, where I teach business law, and I also teach human resources at PLU in the undergraduate and the MBA program. So what this presentation is it's actually the same slides I used when I did this last time. I thought it would be interesting to do an update to the cases that I picked from last time, just to kind of see where they ended up. We're going to talk about a few Supreme Court cases. This is just a very small selection that I curated. There are, of course, many other cases that they have been dealing with, but I picked these few just kind of as an interesting sample, or at least I think that they're interesting, which is the measure that I've been using. Okay, so that's why I always tell my students, I guess, what we learn in the class is what I think is interesting. That's one of the benefits of being the professor. So just as a review, I always like to review this when I give this presentation, because it surprises me how often in like the general news or general conversations, I find confusion or lack of knowledge about how the Supreme Court actually works. And the reason why the Supreme Court is as a faculty member, I'm required to publish, and most of the papers I've written have to do with cases that have been at the Supreme Court. So it's just an area of interest of mine. So one of the things to remember about our US Supreme Court is that it is by and large an appellate court. There are a few quirky instances where it has original jurisdiction, but for the most part, it is hearing appeals that come through the appeals court, the circuit court system in the federal courts. It's one of the things that makes it unique is that they don't hear every case that gets filed. So if you think about, you have your right to your day in court, it generally refers to your trial at the district court, your appeal at the circuit court, but then the Supreme Court gets to decide what cases it wants to hear. And it gets about 7,000 filings, but it only hears about 100 to 150 of those. So it picks the cases it wants to hear through its term. So the term runs from October through June. So this time of year, those of us who watch the court are thinking about what happened in the cases in the last term that ended in June, and starting to think about what are the cases that we expect to come up or that we know that are coming up in the next term, which starts in the first week of October. I'm sure most of you already know we have 9 justices, although most Americans can't name one of them, but which is, I know there's a statistic. I saw your face there, Mary. There's a statistic. A majority of Americans cannot name even one Supreme Court justice. But these are 9 people appointed by the president, confirmed by the Senate, that serve lifetime appointments. And they are the final answer on certain legal issues. So they have an enormous impact on our legal system and the rules that we live by. And most people don't even know who they are. So here's who they are. And so for those of you who have been following this, there's been a lot of, during the Trump administration, there was a fairly substantial ideological shift in the court. So on the left, ideological left, you have Justice Sotomayor, Kagan, and Breyer. On the right, on the ideological right, you have the Supreme Court Justice Roberts, Thomas, who's now the most senior member of the court, Alito, Gorsuch, Kavanaugh, and the newest member of the court, Amy Coney Barrett. What's interesting about this is, there's obviously many issues on which these judges vote ideologically, but there are also issues where they don't. And we're going to see, when I went back to look at the 5 cases that we talked about back in February, when I looked at the outcomes, you'll see as we go through them, they didn't necessarily all vote by their necessarily ideologically aligned, their ideological alignment. So but that's not to say they won't in certain important cases. So this is something I like to cover because I actually just heard an example of this I hear this all the time where this gets there's misunderstanding about it in places where you wouldn't expect it. So we have to remember that what does a court do? It reviews and is charged with the constitutionality of laws. So it is the final say on what is constitutional. And so when we think about how the Constitution works, and we have, in the interest of time, I'm not going to go through all of this, but remember that what the Constitution really, what it does is it gives power to the federal government. It's the document in which the states grant power to the federal government. And then the rights that we have, most of those rights that we commonly think of, the individual constitutional rights, actually come from the Bill of Rights, which protects us from the federal government. And what the mistake that you see a lot, and I just heard this, I was watching on HBO, Ronan Farrow has a documentary, a video version of a podcast where he goes through the whole Harvey Weinstein story. And he was telling the story where he met with Weinstein, and Weinstein threatened to sue them to stop publication. And apparently, according to Ronan Farrow, David Boies, very famous lawyer who was representing Weinstein at the time, said, to Harvey, you have to remember there's a First Amendment in this country, which I thought was amazing because the First Amendment does not apply in that case. The First Amendment only applies in cases where the government is trying to restrict speech, not when private parties are trying to do so. Private parties have a right to restrict speech if they want to, or to contract to restrict speech, but the government can't do that. So this is a very fundamental thing you learn about really early on in law school that you hear about mistakes about all the time. But remember that now what the court does, it really functions in two main ways. And this is very simplifying things, but it either reviews the constitutionality of a law. So Congress passes a law, the court says that's either constitutional or it's not. And when it does that, that's called judicial review. The court's the final answer. There's no appeal from the Supreme Court. The court says this law is unconstitutional. That's it. The only way that ever changes is if you go back to the court and they change their mind, which they tend to do from time to time. On the other hand, the other thing they do is interpret statutes. So Congress is notoriously bad at writing laws. They spend sometimes very little time reading them. They pass these laws and then they cause confusion. One party sues another, and the court says, okay, this statute means X or Y. And in that case, if Congress doesn't like the outcome, they can actually change the law and overturn whatever the ruling was. So Congress can overturn the court's ruling in a statutory interpretation case, but they can't in a judicial review case. Just a little bit of court background stuff. Okay, so let's look at these. I just want to make sure I stay on time. Okay, so I picked 5 cases back in February. I talked about them back in February, and then I went to look up and I followed these cases and I updated the slide deck for them. And Lana, if you want, I don't think I can do it from here, but this is a Google slide deck, and you can access it directly if you want. So Lana, if you want to post the link in the chat, you can all review this or download it if you have any interest in that. Okay, so the first case was Texas versus California. This was the voting rights case, or one of the voting. This is the ACA case. We'll talk about the voting rights case in a minute. So for those of you who haven't been following ACA, this is Obamacare. There's been attack after attack on Obamacare ever since it was passed. And this latest attack made the argument that if you remember Obamacare originally, or the ACA originally applied a penalty if you didn't have health insurance. And in the first challenge to the ACA, the court said that was okay. That was not an unconstitutional mandate because it was a tax, and the Congress has a power to tax, and therefore the penalty was constitutional. But then in the Trump administration came in and zeroed out the penalty. They stopped charging the penalty. So the argument went, well, now since there's no penalty, it's not a tax anymore. So all that's left is the mandate. Congress doesn't have the power to mandate us to get health insurance. Therefore, the statute's unconstitutional. And the court kind of punted on this one. What they did was they didn't actually rule on that question. They reversed the lower courts, which had actually found in favor of those challenging the ACA, but they did so on the basis that both the state of Texas and the people who were suing lacked standing, meaning that they actually hadn't suffered an injury that was could be remedied in court. So it still leaves this question open in theory. If those who are challenging the ACA can find a plaintiff who can actually make an argument that they've suffered an economic injury as a result of this, then maybe the court might take this up again. But for now, the ACA survived the latest challenge. And you can see there, it was a 7-2 vote. So this was not a purely along ideological lines. And I'll take time for questions at the end. So I'll go through these kind of quickly. And if you have questions about them, we can talk. This is the voting rights case. This is Brnovich versus DNC. This had to do with Arizona's voting rights restriction, some laws they passed in Arizona. There were two laws there that were at issue. One was if you cast an out of precinct ballot in Arizona, they can throw it out. So if you go to the wrong precinct and vote, that ballot can be disregarded. And the other law was a law that prohibited what they call vote harvesting, where someone can go and collect up the ballots of people and turn them in. They made both of those illegal. It was challenged under the Voting Rights Act, and which protects against discriminatory voting laws in the United States by the states. But the court ruled that this was not a violation of the Voting Rights Act, that what they call the place and purpose, the place of the voting, like there was no statute, nothing in the statute that said we're trying to prevent otherwise disadvantaged voters from voting. So it was facially non-discriminatory, and the court said that's up to the state to decide. So, but you do notice this was along party lines of 6-3 vote, with the liberal justices dissenting. So this plus you see some other voting rights statutes that have been passed since the 2020 election. The court has sort of, they've already gutted a certain part of the Voting Rights Act anyway. So the court is sort of saying in this case, or people think they're saying, that they're telegraphing that they're really not going to be challenging or overturning state voting restriction laws, so long as they meet these basic standards. Okay, this case, this is Fulton County v. City of Philadelphia. This is actually had some students did a paper on this, and this had to do with the City of Philadelphia. They refused to continue to work with Catholic Social Services because Catholic Social Services would not place, they wouldn't place foster kids in homes where the parents violated the religious beliefs of Catholic Social Services, and so they Catholic Social Services sued as a same-sex case, and the Catholic Social Services claimed that was a violation of their religious beliefs. And in this case, the court voted 9-0 that the refusal to use Catholic Social Services violates the free exercise and First Amendment, free exercise clause of the First Amendment. So they actually sided with Catholic Social Services in a 9-0 vote. This case was another punt. So if you've been following it, when Robert Mueller created his report on the Trump administration, the House has been trying to get a hold of those records, the records that were presented to the grand jury. Normally, grand jury records are secret, but there is an exemption to that secrecy rule for what are called judicial proceedings. So in a judicial proceeding, you can actually obtain these records that are otherwise secret. And what happened here, this is actually really interesting because this is a case where the change in the control of the Justice Department had an impact. Whereas of course, the Trump administration Justice Department was taking the position that the records were not, couldn't be attained. When the Biden administration came in, they actually notified the court that they're changing their position. And so the case was postponed. So they will still hear it, but in this next, the next term, but the court postponed the hearing at the Biden administration's request because the defendant in the case, the DOJ, changed its position as a result of a change in the political administration. I think this is the last case. Yeah, last case. This is the Ford. For those of you lawyers on the call, this case has some interest because it goes back to a civil procedure that you learn about in like the first week of law school. This has to do with where you can sue somebody. We have a variety of courts. When you're a plaintiff, you can pick a court. You can sue in state court, and if you meet the standards, you can sue in federal court. You can sue in the state where you're injured, or in the state where the defendant resides. And there's a whole series of rules that decides that determines where you can be sued. And under the Constitution, the court has said that you can't just be sued anywhere. You can't just pick a random jurisdiction. There has to be, you have to have some connection to the jurisdiction where you get sued in order to be sued there. And in this case, there was a Ford Explorer. It was manufactured in Kentucky, sold actually in Washington to somebody who lived in Oregon. Then that car was sold a few more times, ultimately ended up being owned by someone who lived in Montana. And then that person was, I believe she was killed in the car in Montana. And so it was because it was her estate that sued. And Ford argued that, well, we don't have any connection to Montana. We didn't build the car there. We didn't sell it there. And so we can't, it's not fair to sue us there. You need to sue us in Michigan or in Kentucky or wherever. You have to come to us and can't make us come to you. The court ruled against Ford in this case and said that even though that specific car wasn't manufactured and sold there, Ford manufactures and sells, it doesn't manufacture cars in Montana, but it does have dealers there and sells cars there directly. What the court said was, look, it's not that exact car, but you are there, you have enough contact with the state of Montana where it is fair to sue you there. And so they ruled against Ford in this case. And this is an example of a very technical kind of case that deals with civil procedure rules that go back, hundreds of years. And the court is constantly kind of tweaking it as these cases come up. But you'll notice here, this was an 8-0 vote. Justice Barrett didn't vote because this case was argued before she joined the court. But that's another example of how the justices don't always vote straight along ideological lines, which some people tend to think they do, but they definitely don't. So those were the 5 cases that I picked, and I think we're doing pretty good on time. Just a few notes. If you're interested in any of these cases, at the bottom, what I did with this deck, I'm going to go back a few slides. If you click on the case name down on the bottom left, it will actually open up the page that about that case. And now I've managed to sort of screw myself up here. Okay, so I think I've lost it. I'm going to stop sharing. But there's information if you're interested in any of those cases or other cases in my slide deck. Oh, actually, I can reshare here. Let me go back to sharing sorry about this. You can actually go back into these if you want, and it's not going to let me do it. Okay, and read about the cases. And there's 2 really great websites to do this. One of them is called SCOTUS blog. The other one is called OYEZ or OYEZ. And every case has a page on those sites, and you can read about what happened, who voted for it, why they voted for it. You can read analysis about each of those cases. So if you're interested in following Supreme Court cases, you can, those sites make it very easy to do that. And I think the only other thing I had on those slides were just, I had a slide about PLU, just a little bit of publicity for PLU, go Lutz. And we're starting up again in the fall. So, so we, just like to get the word out about PLU. And I think that's all I've got for so I wanted to end on time. So we're right at 1 o'clock. Does anybody have any questions or comments or thoughts about any of this?
Hey, Ralph, this is Denny.
Yeah, Denny.
The voting rights thing has really got me worried. So the states are, some states are passing laws that are very restrictive to restrict voting and then maybe turn votes away that they don't like and things like that. They're actually passing laws, and the Supreme Court has indicated that they're not going to interfere with that. So I'm a little concerned about that. I don't understand. It's like a states' rights thing, or why isn't the Supreme Court saying no? You can't restrict voting.
Yeah, it's a good question. So basically, this kind of goes back to another common misperception about our system, which we talked about a little bit last year, was when we were in the midst of the election. But we don't have a federal election system in the United States. We have state elections. So, the U.S. Senate members of the Senate and of the House, they're elected by the state. The state runs those elections. The president is actually also elected by 50 individual state elections. We don't have a federal election. So what the Voting Rights Act did was it said that it made it illegal for the states to restrict voting based on discriminatory purposes. But beyond that, the states can run their elections any way they want. They're sovereign, and they can send whoever they decide to send to the federal institutions, the House, the Senate, and the presidency. So constitutionally, the federal government doesn't have a whole lot of power. Now, in the past, prior courts that had more of a liberal ideological leaning were more aggressive as far as the kinds of things that they restricted. But the more conservative court is kind of going back and saying, hey, wait a second, states have the right to run their elections the way they want. The only thing they can't do is violate someone's constitutional rights, and nothing we've seen so far, we believe, violates constitutional rights. I think you'll see more challenges to the case because the states are getting more emboldened. They're passing more and more restrictive laws, especially in the South. And I think you'll start to see those cases kind of work their way through the system. And we're going to have to figure out where the court thinks the line is on that. But in the case of the Arizona, the court said, look, it's perfectly reasonable for Arizona to say that if you cast a ballot in the wrong precinct, we're not going to count that. That's not a constitutional violation. We're also not going to let people go collect up votes from other people because we are concerned about election security. Even though those two things ultimately have a disproportionate impact on minority voters, that the court said they don't have a discriminatory intent, and therefore the state can make its decisions about how it wants to run its elections. Okay. So I think you'll probably see. So go ahead, Mary.
If someone were to challenge then though some of the gerrymander, I don't know that that's laws as much as it is just a practice. Is right. That and they are clearly for racist reasons, then that would go all the way up to the Supreme Court, and then they would. Right.
Yeah. So a law, the only thing the Supreme Court can do about a state law is find it to be unconstitutional, right? Well, it can do one of two things. It can find it to be unconstitutional, or it can interpret it. Generally, the federal courts stay out of trying to interpret state law unless it's a what's called a diversity case where you have two people from two different states suing each other. But for the most part, the court is going to say, look at a law and say, is this constitutional? And if it doesn't violate a constitutional right, if it determines that it doesn't violate a constitutional right, it's going to stay out of it. So so what's happening is those who are trying to pass restrictive voting rights, they were clever, of course, about this, and they write statutes that on their face don't seem to have any discriminatory intent, right? They seem very benign. Someone votes in the wrong place, we're not going to count that vote. But of course, they know that the people whose vote they don't want to count are more likely to vote in the wrong place. So that, it's a proxy for that. But the Supreme Court, at least so far, has said we're not going to look at it that way. We're going to look at the statute on its face, and we're going to defer to the state to let the state decide how it wants to hold its elections. We're not going to interfere with that unless it's a patent violation of the Bill of Rights.
So they don't look at the impact, they look at the intention.
Yeah, right, exactly. And whereas previous courts were more likely to say, hey, wait a second, we can see right through this. This has what we call a disparate impact and not necessarily a discriminatory intent. But this court, this more conservative court, is being more deferential to the states, which you would expect from the conservative ideology. Ideology generally is more deferential to states.
How about we have one more question? And Ralph, thank you so much for taking time out of your baseball schedule for this.
Yeah, no problem. Well, we scheduled this before the baseball trip, so
Yes,
so I'm glad
good.
it worked out. Yeah.
One more question? Anybody? No.